Hi, I'm Aron Benjamin. Welcome back to Legally Speaking. This month, we did a Maryland law update. In 2023, there's going to be a number of changes to laws impacting the workplace, your retirement benefits, and marijuana. Joining me is Sarah Broder from our Trust and Estates Group, who's done a lot of work on the Secure Act 1.0 and 2.0, as well as Darla McClure from our business group, who talks about the impacts to minimum wage and what it's like in this post-COVID environment for employers. I'll be discussing the new marijuana laws, and I hope you enjoy the conversation. That's always like what you think is going to happen.
Until somebody dropped their camera bag and had to go back.
Oh, leave the camera, go to camp, right?
It's like, how valuable are these pictures?
Right, exactly. Well, welcome to Legally Speaking. I'm here, this is Aron Benjamin. I'm here with Sarah Broder from our Trust and Estates Group, and here with Darla McClure, a partner in our business group. And we're doing a Maryland new law update for 2023. We're going to cover a broad spectrum of law, and I think you're going to find a lot of interesting pieces that's going to really impact your everyday life. And one of the things, the thing I would like to start with was something that you said to me, and it blew my mind when we were just talking and throwing ideas around of what we're going to do here. And I generally consider myself a kind of a smart guy and someone that's on top of the law, because I'm a lawyer and, it's kind of my thing. And I just said, Sarah, so what's new in trust and estates law? What are you doing these days? You said, well, in 2023, Secure Act 2.0 is really making an impact. And two things popped in my head. One, 2.0? Where was 1.0? And why don't I know about it? And two, what is the Secure Act? And you said it like I should know what it is, and I didn't. And so I'm putting it out there to the world. Please help me.
Sure. Also, it's probably because I hang out with too many tax people that I just assume you know. So that's on me. So let's go back to Secure 1.0, which was passed at the end of 2019, went into effect in early 2020, and that made a really big change to one aspect of at least estate planning with respect to retirement accounts, like individual retirement accounts, IRAs, things like that. So basically, what Secure 1.0 did, there's other aspects of it too, but this was kind of the main takeaway, was when you were leaving a retirement account like an IRA to a designated beneficiary before Secure Act, you could, let's say, leave it to your adult child, and that adult child upon your death would get that retirement account in the form of an inherited IRA, and they would be able to take out the required minimum distributions from that account over their life expectancy.
And would there be any penalties to that, or was it just kind of it would just translate into the adult child?
It would just transfer over. They would get their own account number, but it would be the same money, just kind of transferred over, rolled over into their new account, but they'd still be able to stretch out, they called it the stretch IRA. They'd be able to stretch out the distributions from that account over their life expectancy, which if you're talking about a traditional IRA is pre-tax money. So when you take it out of the IRA, you have to pay income taxes on it. So to be able to stretch out that income tax hit over their life expectancy is really significant. So what Secure 1 did was make most beneficiaries have to take out that money now that they inherit within 10 years of the account owner's death. So first I'll say Secure 2.0 was passed in December of last year, so in 2022. And instead of going into effect in 2023, every provision has a different effective date, which is really, that's why I have notes. Because memorizing it is kind of crazy. Right. So it varies. Some of them go into effect immediately. Some go into effect 2 years from now, 3 years from now. It's all over the place. But there's a lot of provisions, and the ones that I kind of wanted to talk today about, since we're talking about employer-related topics, is the goal of this act is really to make it easier, especially for small businesses, to be able to establish 401ks or similar kinds of retirement plans for their businesses and for their employees, and also to make it easier for the employees to save. So there's provisions, for example, there's one, it's a pretty big one that requires that everybody in a plan be automatically enrolled in a 401k or a 403b. Right now, you have the ability to opt into a retirement account at your employer, but this changes it to make it mandatory.
Let me turn to our business attorney here. And you do a lot of work with small and medium-sized regional corporations. Do you see an impact coming from this in terms of, you read the news these days and you see there's a lot of competition for hiring. There's retention is an issue. Is this really going to be something that from the people you've talked to, is this going to be something that's going to be helpful?
I don't know yet. I mean, I feel like what Sarah said is there's so many different effective dates in terms of when we have to start really worrying about this and advising our clients. I know we are looking into now, and we've had seminars on it, and Sarah has talked at length about it, but I haven't heard from my clients yet in terms of how is this going to impact me? When do I need to start worrying about it? It hasn't really been on anybody's radar till right now.
Would it be fair to say that whether or not they're thinking about it, it is going to impact them?
Absolutely.
Yeah, and that from what it sounds like, it's really only been in effect for about 6 weeks or so.
Yep,
right.
But it's
so we're all still learning.
It's going to be a tidal wave come 2024.
Right.
And
there's no regulations on it yet, so we don't.
Yes.
Yeah, there's a lot left unanswered. Just to give you another example of something that is going to impact small businesses, is there's a provision now in Secure 2.0 that military spouses can get an accelerated eligibility to participate in their employer-sponsored retirement plan. And the point is logical, right? Because if you're a military spouse, you're moving every 3 years, right? And so you're rarely at an employer long enough to become eligible under the terms of their plan. Sometimes it's a year, sometimes it's 2 years. You're never really able to save enough for retirement that way because you have to restart the clock every time you move. So this provision allows employers to kind of accelerate that and make it an immediate eligibility to participate. And it gives small businesses a tax credit for doing that.
Oh.
Right? And there's a couple other provisions in Secure 2.0 like that. One of them is student loan repayments. And this has obviously been a big topic in the news lately. A lot of the new, hires are probably going to be people with student loans. So the goal here is to allow employees who are paying back student loans the ability to save for retirement while doing that, because a lot of times they don't have enough cash to put into a 401k and to pay off the student loans, right? So if they can show that, or if they can certify that they're paying off a student loan, the employer can still make a contribution to their account by, if they have a matching policy, they can match the amount of the student loan payment into their 401k. So essentially the employee doesn't have to put into their 401k, they can just pay the student loan off, but the employer can treat that as a contribution to the 401k and match.
Wow.
Which is great. And what's great about this also is that the student loan is really broadly defined. It doesn't have to be a federal student loan or anything like that. It's just a loan taken out to pay for education.
So a private loan or?
Private loan, it could be a personal loan, honestly.
Really?
I think that the way that it's written, in my opinion, could be anything as long as it's for that purpose.
So I want to put a pin in that because I do kind of want to get an idea of, before we talk about how the impact of Secure Act 2.0 or even medical marijuana or anything, or recreational marijuana now in Maryland, the state of employers in the state of Maryland, and there have been some new laws that are impacting employers in onboarding and retention. I think there was an increase in minimum wage. Is that correct?
So Maryland is at $13.25. Montgomery County, where we are, is at $15.65 for large employers. And the federal minimum wage is still $7.25. So the goal was to get Maryland up to $15 an hour, and that's the trajectory that we're seeing over the next couple of years.
Sounds like we're getting close.
Yeah, a couple more years, and I think we'll be there.
So what else? There's we were just talking beforehand. You said,
Yes.
I had read something about kind of an expansion of some laws relating to sexual harassment, but then you also said there was an ADA aspect to it as well.
Yes, there were probably three things that employers need to pay attention to that happened in 2022. Right, we're in the 2023.
Right.
Legislator right now is talking about new laws and things like that. But 2022, what we saw was the definition of harassment or sexual harassment has changed. It had always been, in order to be actionable conduct, the conduct had to be severe and pervasive. That was what the language was. Now they've removed that and said, it just has to be enough to warrant the court to be able to say, yes, this harassment has occurred, right? So it's softened that, and it's going to be easier now for employees to make claims against an employer based on harassment or sexual harassment, because it doesn't have to go to that severe and pervasive level. Now, what we're hearing, even though this is new, is that, it's still one-off comment or something, limited, or a single instance is not gonna, take it to actionable conduct. But employers need to be mindful that it's not a heightened standard anymore.
Yeah.
It's a lot lower. And then second, that you mentioned the ADA. So in Maryland, reasonable accommodation with regard to somebody that has a disability applied to an employee, right? Mm-hmm. Now it goes as far as to an applicant. So an applicant that needs a reasonable accommodation because of disability in the hiring process is also allowed to request that.
It's interesting. And as you're saying, this is under the banner of ADA, does that mean a failure to comply will then put you in the penalty area of ADA?
Yeah, and maybe I should clarify. It's okay. ADA is a federal law.
Right.
We're talking about a Maryland law. Okay. Maryland has a similar scheme with regard to disability and reasonable accommodation. That kind of, for the most part, mirrors the federal law. Montgomery County has one as well. Other counties have them. So it's not technically an ADA issue, but it's going to fall within the same scheme. A lot of the language is the same in the statute.
And either way, it's going to make...
have penalties associated.
Right.
Somebody could file a discrimination claim based on a disability if you fail to accommodate them during the hiring process. There's another law that I wanted to mention.
Please do.
It's called the Time to Care Act. Oh. And that is the law that went into effect that requires employers to provide contributions to a fund that employees can access in the event of a serious illness, birth of a child. That kind of mirrors what the FMLA does in terms of time, 12 weeks. It's capped at $1,000 a week. But what employers need to know is that starting October 1, they need to start contributing to that fund and setting up payroll and things of that nature. So I just want people to be mindful that they need to talk to their payroll service providers in order to set that up. The employees can't access the fund until 2025, I think. Yes.
Does it earn interest?
2025.
No.
And right now, there's no regulations. Like you said in the Secure Act, supposedly in June, we're going to get kind of the information in terms of what this all means and how this is going to work. So stay tuned.
So that's really interesting because there's kind of a counterpart. There's a couple provisions in the Secure Act that are very similar. That allow for, there's one that allows for an emergency fund linked to your pension, your retirement account at your employer. And employers can make it automatic that the employees opt into it. And they don't have to, but they can. And then the amount is capped at $2,500, and then the employee can take it out up to 4 times per year. And then
Is that $2,500 per year?
It can't. I think the account can't exceed $2,500 at any time.
But it's like you could refill it.
Correct.
Okay.
Yeah. When you take it out, you can kind of pay it back in.
Mm-hmm.
But the contributions to that emergency fund also qualify for employer matching for retirement plans. So if you contribute to your 401k and your employer matches, they'll put an equal amount into your 401k. But if you're contributing to this emergency fund instead of your 401k, the employer is still required to match under the terms of their plan.
Match into the 401k?
Into the 401k. Wow. Yeah.
So it's expanding the definition of what matches into
Right.
a 401k.
And you can take it with you. So an employee can, if they terminate employment, they can take it in the form of a Roth account, which is a post-tax account.
Sure.
So that if they take it out, they won't have to pay income taxes on it. So
That's huge.
it is interesting.
Huge.
Yeah. I didn't know about the Maryland one, so that's interesting. That's a common, I guess, a new theme, trying to get people to be able to save for a rainy day.
Mm-hmm.
Yeah.
Give people some monies, in the form of wages when they're out.
Right.
Because FMLA, which is a federal law, doesn't provide for paid time. If you you have the 12 weeks available to you.
They can't fire you in 12 weeks. They don't have to pay you.
They don't have to pay you.
Right. So I came to you and I said, now that all that's going away, what's the legislature going to do? What are governments going to do? What are counties going to do? Because you can't just go back to where it was.
Right. And I think, there's certain laws that, if Maryland were to go back into a state of emergency, would come back into effect, right? Certain things. But right now, we're not seeing that. So employers, private sector employers, are taking a look at their policies and saying, well, what do I have to do? Well, first and foremost, you got to keep your employees safe, right? So you might have relaxed the mask mandate, but there's some employees that still want to wear a mask, which is fine. We're still keeping some of the plexiglass up. We're still telling people, keep your distance. Don't be right next to your neighbor all the time. And if you're sick, stay home, right? And that comes into play with, well, do I have sick leave, right? So, the person that doesn't have as much sick leave may not want to stay home. So as employers, you're grappling with those issues and trying to figure out what works and what you can do to keep your staff safe.
Speaking of laws that just got passed, I know you two are excited for me to talk about.
I am actually.
Is the it's the personal use, recreational use of cannabis in Maryland. The headline of that, of course, is July 1st, 2023. It's a free-for-all. Cannabis for everybody, right? Yeah. So that's not true. It's not. It's not being handed out, and no matter how many times I'm asked that.
No, I couldn't be in the office that day.
I should say, no matter how many times Sarah asked me that. No, but it does make cannabis legal for recreational use up to 750 milligrams of THC, which is a lot. I mean, that's a significant
Sounds like
amount.
a lot.
It's a lot.
That's
It sounds like not that I would have.
Well, I'll tell you I've had an interesting relationship with cannabis professionally as a former prosecutor who has put people in jail for possession of marijuana 9, 10, 11 years ago. To see it go from illegal to decriminalize, then to medically necessary, now to recreationally necessary, has been a journey, but I think at the end it's going to be fruitful for people who, not just people who want to use it, for people who want to sell it or get involved in the business. And I wrote down a couple of things that I find fascinating that you two talked about unprompted that are a part of the Maryland law, in addition to the July 1st date. First off, there is what I think might be the most important thing that nobody's talking about with this, is that there is now a roadmap to clear convictions for marijuana on your record. You know, the idea of creating a regulatory scheme is huge in this whole thing, because if you look at the other states who now have recreationally legal cannabis, you see a wide gulf between states who thought about it ahead of time and had something in place and then passed the law, like Colorado, like Oregon, and now like Maryland. I would put them in the same category in terms of being forward thinking about it, as opposed to a state like New York, who basically in the span of 3.5, 4 years went from illegal to completely legal. And there is no regulatory scheme at all set up for everything from growers to distribution to getting it to the public. And it's been 2 years since it's been recreationally legal, or around 2 years in New York, and it's just not there. But in Maryland, because it has been medically legal for medical marijuana, has been around for a number of years. Not only is there a regulatory scheme, there's a website you go to get all the information. And you know, if you drink at work, what happens?
Well, as long as you have a no tolerance policy that says you can't drink, then you can be terminated or disciplined for drinking on the job.
But I bet a lot of those no tolerance policies talk about alcohol.
They talk about alcohol and drugs.
Okay. And the definition of drugs is undefined generally, right?
An illegal substance.
What if it's not
or
illegal?
a illegal use of a prescribed substance. So with regard to marijuana, it's still under federal law an illegal substance. And so if you have a policy at work that says, for example, that you drug test randomly and the person tests positive for marijuana, even if they have a medical marijuana card, even if it's legal as of July 1, they can still be terminated in marijuana.
And nothing about this new law is going to change that.
No. A lot of states are, changing their laws to say you can't discriminate against somebody who tests positive, right? You can't fail to hire somebody that tests positive if they do a drug test at the time of the beginning of employment during onboarding. People have modified their laws to deal with that. Maryland has not. Most of my clients that don't have, certain federal requirements if they're working for the government or something like that, private sector, have done away with testing for marijuana if they do drug testing at the time of the onboarding, right, at the time of the beginning of employment, or random testing. They're eliminating it. They are still testing for marijuana if there's been a workplace accident.
So let me ask you, why do you think they're eliminating it without being told by the government or a regulatory agency or an oversight agency or if it's a doctor's office, a medical board or something like that? Why do you think they're just doing it on their own?
Because what we've seen during COVID, you all heard of the Great Resignation. People are leaving. There's not the applicant pool is actually smaller, even though everybody's leaving. You think that would be bigger, but it's not. And so people that are using marijuana recreationally or medically, shouldn't be eliminated from that pool. I mean, we need good people.
I'm kind of picking up on the theme on all of this. You wouldn't think that retirement savings, small business, and cannabis would have a theme.
This is the beginning of a bad joke.
I know, right? I'm not a good joke teller, so I don't.
Into a bar.
But it sounds like employee retention is an important issue across the board.
Absolutely, right now. I mean, I just read something the other day in terms of surveys that are done, and employee morale is like at the top. We have good people. We've trained them. We want to keep them. How do we do that? We have to bolster employee morale. We have to look at some of these new things that are out there and what we're going to do about them. So, absolutely.
21st century workplace. 23 years into the 21st century.
Yeah, right.
Right? and we're not going to hold you to this, even though this is going to be recorded for posterity's sake. What do you see next in the areas we just talked about when it comes to tax schemes with retirement savings, laws that affect businesses, especially small and mid-sized businesses like you deal with, and then we'll take a stab at cannabis. So I'm going to start with you, Sarah. What do you think?
So if you take the totality of the different provisions in Secure 2.0, I think, and if you read kind of the reasoning behind all of them and why they were included in the bill, I think you can kind of see the path we're going towards, which is we may not have Social Security forever. And we need to get, especially the younger generations, acclimated to the fact that they have to have some involvement in their own saving. Mm-hmm. And I think COVID really highlighted how little people saved for a rainy day in general, and really made it more apparent that that's a glaring issue, not just saving for retirement, but saving for a flat tire, right? Right. Saving for having COVID for 2 weeks and not getting paid, right?
Having a kid.
Right? Anything that's a major disruption to your daily life, I think that if there is a Secure 3.0 or some other similar law, I think that that's where we're going, is getting people more invested in their own future.
Darla, what do you think in terms of workplace law? This is something that I have had experience with in a former life, and you're elbow deep in it all day, every day. If you were going to look 2-3 years down the road, do you think there's going to be more of a backlash? Because it seems like more employee-friendly statutes that are coming out. Do you think there's going to be a backlash? I don't want to use that word because it has a negative connotation, but more of a swing of the pendulum to the other side, where maybe more employer-friendly legislation? Do you think it's going to keep? We're not at the apex of the swing on the employee side, or am I looking at it just two-dimensional?
Right. I mean, the thing with employment laws is there's always something new, right? Every year there's a handful of new employment laws, and you have to stay up to date on it. And it's, I feel like the landscape from an employment side is always changing, right? I think you need to be mindful of that. I do think that a lot of the legislation is employee friendly. I think that's what we're going to see. And I think that, as small to medium sized businesses, some of that's going to hurt their bottom line.
And I think coming back to what you were talking about with small businesses and, what are the things they need to look out for? The next step in this, and we're seeing it in Colorado. Colorado's kind of the bellwether. Mm-hmm. And, as someone who moved here from Colorado, I have family and friends that are there, and it's kind of a bellwether, because the next step, the 3.0 of this, if you will, is, okay, now that it's a part of our society and it's here to stay, we need to be safe about it, and we need to be able to make sure that it doesn't interfere with our lives, people are driving, or our businesses. And laws like that, those nuisance laws, those use laws, safe control and regulation on who could be providers and users, that's now the important. That's going to be the next debate on all this. And one of the